Hello there. Over the past few weeks, a lot of people across the tech sector, startup community, and immigrant workforce have been quietly asking the same question. What happens when a state decides it has had enough of what it believes are abuses inside the legal immigration system and steps in with its own investigation? That question is now front and center after Texas confirmed to have launched a formal investigation into alleged H-1B visa fraud, a move that could ripple far beyond state borders and affect companies, workers, and families who thought they were safely inside the system. In this video, let us understand the latest updates and their implications for everyone connected to the H-1B program. If you find this video helpful, please hit the subscribe button, turn on notifications, and give it a like so you never miss important updates delivered straight to your smartphone. Now, let us get into the video. Welcome to U.S. Immigration Info, your trusted source for accurate, comprehensive, and timely immigration information that helps you understand the complex and ever-changing landscape of U.S. immigration law and policy. Today, we are covering a significant development that has created anxiety and uncertainty across immigrant communities, particularly among highly skilled workers who depend on employment-based visas to live and work in the United States. The H-1B visa has always been one of the most talked about and misunderstood employment visas in the United States. For many highly skilled workers from around the world, it represents opportunity, stability, and a possible path toward a green card and eventually citizenship. It is the visa that has allowed countless engineers, doctors, researchers, and other professionals to build their careers and their lives in America. For employers, it is a way to fill specialized roles when qualified U.S. workers are difficult to find, allowing American companies to remain competitive in the global marketplace by accessing the best talent regardless of where that talent was born. But for years, critics have argued that the system is vulnerable to abuse, manipulation, and outright fraud. They point to companies that allegedly game the system, file petitions for jobs that do not really exist as described, or pay wages that are far below what the position should command. These criticisms have created political pressure for reform and enforcement, and now Texas is signaling that it believes some of those concerns rise to the level of state-level enforcement action that goes beyond what federal agencies have been doing. According to officials in Texas, the investigation is focused on whether certain companies and intermediaries may have misrepresented job roles, wages, or work arrangements connected to H-1B petitions. While immigration enforcement is typically a federal matter handled by agencies like U.S. Citizenship and Immigration Services, the Department of Labor, and Immigration and Customs Enforcement, states can become involved when allegations intersect with labor laws, consumer protection statutes, or business fraud regulations. That is the legal doorway Texas appears to be walking through to assert jurisdiction over these matters. At the center of this effort is the Office of the Texas Attorney General, which has broad authority to investigate deceptive business practices and violations of state law. Officials have not publicly named specific companies at this stage of the investigation, but they have made it clear that the inquiry is active and ongoing. Subpoenas have reportedly been issued. Document requests have gone out to companies. Interviews are being conducted with individuals who have knowledge of the practices in question. All of this signals that this is not a symbolic announcement designed to generate headlines, but a real enforcement action with potential consequences for those involved. For H-1B workers already in the United States, this news has understandably triggered anxiety and concern about what it might mean for their situations. Many people hear the word investigation and immediately worry about deportation, visa revocation, or sudden job loss. They wonder whether their own status might be affected by actions taken by their employers, even if they personally did nothing wrong. It is important to be very clear here about what this investigation is and is not targeting. This investigation is not aimed at individual visa holders simply for being on H-1B status. The Texas authorities are not going after workers who followed the rules and are doing the jobs they were hired to do. Instead, The investigation is focused on alleged misconduct by employers or third-party staffing firms that may have made false representations in visa petitions or violated labor laws in how they treated H-1B workers. However, when companies come under scrutiny like this, workers can still feel the impact even if they are not the targets. Investigations can lead to layoffs, contract terminations, or sudden changes in employment arrangements that leave workers scrambling to find new sponsors or maintain their legal status. One of the core issues investigators are reportedly examining is whether some employers listed full-time specialty occupation jobs on paper while actually placing workers in very different situations in reality. The H-1B program is designed for specialty occupations that require at least a bachelor's degree in a specific field. The job description in the petition is supposed to accurately reflect what the worker will actually be doing. If a company files a petition describing a complex engineering role, but then places the worker in a lower skill position, or keeps them on the bench without meaningful work, that discrepancy between what was filed and what actually happens can constitute fraud. Another area of concern involves wage levels, which is one of the most scrutinized aspects of the H-1B program. The H-1B program requires employers to pay at least the prevailing wage for the position and location where the work will be performed. This requirement is designed to protect both the foreign workers from exploitation and American workers from unfair competition from lower-paid foreign labor. If a company claims a high-skill role that should command a substantial salary but pays far below market rates for that type of work in that geographic area, that discrepancy can raise red flags not just for federal agencies that oversee the program, but also for state labor authorities who enforce wage and hour laws. This matters because the H-1B system already operates under intense scrutiny from multiple directions. Each year, demand for H-1B visas far exceeds the available supply of visas that can be issued, leading to a lottery system that leaves many qualified applicants without visas through no fault of their own. The competition is fierce, and many talented individuals see their applications rejected simply because there are not enough visa numbers to go around. When allegations of fraud surface, they fuel political arguments that the program is broken or unfair, that bad actors are taking visa slots that should go to legitimate applicants, and that the system rewards those who cheat rather than those who follow the rules. That criticism, in turn, can influence future policy decisions, processing timelines, and even the tone of enforcement under the current administration, which has emphasized aggressive oversight of employment-based visas. The more fraud allegations circulate, the more pressure builds for crackdowns that affect everyone in the system, including those who have done nothing wrong. From a legal standpoint, the Texas investigation raises a bigger question about how state and federal roles intersect in immigration-related enforcement. Immigration status itself remains a federal matter, governed by federal law and enforced by federal agencies. The federal government has exclusive authority to grant or revoke visas, to deport individuals, and to set the rules for who can enter and remain in the country. However, employment practices, wage compliance, and business representations often fall squarely within state jurisdiction under state labor laws, consumer protection statutes, and business fraud regulations. If Texas uncovers evidence of systematic misrepresentation or labor violations by companies operating within its borders, it could take action under state law to impose penalties and require compliance reforms. Additionally, it could refer findings to federal agencies, triggering audits or enforcement actions by USCIS, the Department of Labor, or other federal authorities. This state-federal coordination, or sometimes conflict, is an increasingly important dynamic in immigration enforcement. For companies operating in Texas, especially those heavily reliant on H-1B talent, this investigation is a warning shot that should prompt immediate attention to compliance. It suggests that compliance cannot be treated as a paperwork exercise where you file the right forms and then forget about whether reality matches what was filed. Job descriptions must match the actual work being performed, Wage levels must be defensible and consistent with prevailing wage requirements. Worksite arrangements, including remote placements and third-party client sites, must be properly disclosed in petitions. In the current enforcement environment, any gap between what is filed with the government and what actually happens on the ground can become a serious liability. Companies that have been cutting corners or treating H-1B requirements as mere formalities may find themselves facing investigations, audits, and penalties that they never anticipated. The timing of this investigation is also notable and adds to the anxiety many H-1B workers are feeling. Many H-1B workers are already navigating extremely long green card processing timelines, waiting years or even decades for their priority dates to become current in the visa bulletin. For workers from countries like India and China, the backlogs are particularly severe, with wait times that can stretch beyond a decade for employment-based green cards. For these workers, job stability is not just about income and career progression. It is about maintaining lawful status while their cases move slowly through USCIS and later through the National Visa Center and consulates abroad. A sudden employer-side investigation can throw those carefully planned timelines into chaos. If a worker's employer comes under investigation and the company faces disruption, the worker may need to find a new sponsor quickly to maintain status. That process takes time and is not guaranteed to succeed. For workers who have been waiting years for their green cards, the thought of starting over with a new employer is deeply concerning. At the same time, Texas officials argue that their actions are about protecting workers and the integrity of the labor market, not about punishing immigrants. From that perspective, cracking down on fraudulent practices is framed as a way to ensure fair wages for both American and foreign workers, honest competition among businesses, and lawful business conduct that respects both immigration and labor laws. Officials argue that companies that commit fraud harm everyone, including the H-1B workers they employ, who may be paid less than they deserve or placed in jobs that do not match their skills. Whether one agrees with that framing or not, the practical reality is that enforcement attention tends to create a chilling effect across entire industries, not just among those accused of wrongdoing. Companies that have nothing to hide may still become more cautious about sponsoring H-1B workers, worrying about the additional scrutiny and compliance burdens. That caution can reduce opportunities for skilled immigrants, even when no actual fraud is involved. For H-1B workers watching this unfold, the most important thing right now is not panic, but awareness and preparation. Know your job description as it appears in your H-1B petition and make sure your actual work matches what was filed. Understand your wage level and whether it meets prevailing wage requirements for your position and location. Keep copies of your offer letter, pay stubs, and work assignments so you have documentation of your employment situation. If your role or location changes significantly, understand that such changes may require an amended petition, and make sure your employer is aware of and complying with that requirement. These are not new rules created by this investigation. They have always been requirements of the H-1B program. But moments like this investigation highlight why they matter so much and why workers should not assume that their employers are handling everything correctly. Taking responsibility for understanding your own situation is one of the best protections you have. It is also worth noting that investigations like this often take months, sometimes years, to fully resolve. Early headlines can sound dramatic and create immediate anxiety, but the legal process is slow and methodical. Allegations must be proven through evidence. Companies have the right to respond to accusations and present their side. Findings may ultimately lead to settlements, fines, compliance agreements, or referrals to federal agencies. Rarely does everything happen overnight, even if the fear feels immediate when you first hear about an investigation. Looking ahead, this case could influence how other states think about their role in employment-based immigration oversight. If Texas proceeds aggressively with this investigation and sees political or legal success from its efforts, it may embolden similar actions elsewhere. Other state attorneys general may decide that they too should be investigating potential H-1B fraud or labor violations in their jurisdictions. That could create a patchwork environment where companies face not just federal scrutiny from USCIS and the Department of Labor, but also state-level investigations tied to labor and business laws in multiple states where they operate. For policymakers, this moment adds fuel to the broader debate about reforming the H-1B program itself. Supporters of reform argue for higher wage floors that would make it harder to underpay H-1B workers, stricter oversight of how the program is used, and better enforcement mechanisms to weed out bad actors while allowing legitimate use of the program to continue. Critics of aggressive enforcement warn that excessive crackdowns risk driving talent away from the United States and harming innovation as skilled workers choose to go to other countries with more welcoming immigration systems rather than face uncertainty in America. Caught in the middle are the workers themselves, many of whom followed every rule in good faith and now worry about consequences that arise from actions beyond their control. They did what they were supposed to do. They applied through proper channels, obtained their visas lawfully, and went to work for employers they trusted. Now they find themselves anxious about an investigation targeting their employers, wondering what it might mean for their own futures. As this investigation develops over the coming months, we will be watching closely for concrete outcomes that clarify what all of this means in practice. Will specific companies be named publicly as targets of the investigation? Will penalties be imposed on companies found to have violated state law? Will federal agencies take follow-up action based on referrals from Texas authorities? And perhaps most importantly, will this lead to real structural changes in how H-1B cases are reviewed, approved, and monitored going forward? For now, what is clear is that the immigration landscape remains unsettled and requires constant attention from those whose lives depend on it. Enforcement priorities shift with political winds. Processing timelines stretch in ways that make planning difficult. Political pressures rise and fall based on economic conditions and public sentiment, and actions taken in one state can send shockwaves through the entire national immigration system. If you are an H-1B worker trying to build your career in America, an employer trying to sponsor the talent you need, or a family waiting on a green card that depends on continued H-1B employment, staying informed is no longer optional in this environment. It is essential for protecting your interests and making good decisions about your future. That is all we have for this bulletin. U.S. Immigration Info Channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas, such as B1 and B2, work visas, such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. If you have not already, please subscribe to U.S. Immigration Info Channel. Thank you for watching, and we will see you in the next video.